Hi, Natasha. Hi, James. Welcome to Legal Practice Intelligence.
Hello, David. Good to be with you.
Hi, David.
Hi. I was really interested the other day when I read the article in the Financial Review about you guys, and sort of piqued my interest. I thought our subscribers got to know; they've got to find out some more. So, do you want to do some introductions about your firm, what you're doing, and markets you're actually working with, and value propositions, etc.?
Sure can. So we are a boutique digital firm that runs across Australia, but we tend to service clients globally, not giving legal advice globally, but certainly giving commercial business advice globally, but focused on legal advice in Australia. We have partners all over Australia. We even have a partner in Launceston, and we have lawyers even in Brisbane. You know, we have people everywhere. The idea being that there is a gap in the market for emerging tech. And if you don't have a firm that has slightly different KPIs to a normal or traditional firm, then there isn't actually the expertise to service emerging tech because it's so changeable.
It's interesting because I think one of the comments that you sort of made in the article that I read was about, said at the end, was actually the time in researching, because it is actually an evolving field. It's fast moving. There's new regulations involved, and I noticed as well that you've been an expert that's been advising, I guess, in terms of policy and those kinds of areas as well. Do you want to tell us more about that?
I think that's right. So one thing that lawyers, we are officers of the court. So we also have to be very concerned about legal risk. So we have duties, and we're very conscious of the duties of our clients as well. And one thing that became apparent is that we are in an industry where people, they've not been cognizant. There's a lot of discussion about it. Often things they're unregulated, but actually we do sit in a regulated world. It's a really uncertain world. It's not always clear what the regulations are, and the regulations are not always fit for purpose. So because of that, some of what Stirling and Rose does, and certainly James and I in our previous careers working in big global law firms, has been about trying to help regulators and help governments to understand how the law should move forward, because we get to see, we're horizontal, we get to see lots of different industries, we get to see lots of different startups, and we know where the pressure points are. So we can, a part of our calling is to be able to actually help push the law of where it should go, the development of the law itself.
No, brilliant. I mean, it's actually interesting because people sort of describe the world of Web3 and crypto and blockchain as a wild west, but as you sort of say, it's not. There are regulations, there are some regulations in place, there are frameworks in place. It's just people don't have the awareness of that. And I guess that sort of brings me to the next point, just so I can sort of step back a little bit, which is around, you know, for our community, in terms of just explaining, I guess, from a top level point of view, you know, Web3, blockchain, crypto, and that kind of thing. How would you basically best describe it to another law firm?
James, you want to have a crack?
I'll start with the blockchain. The blockchain is I think that's I think the market's evolved, but there was a traditional confusion between blockchain and crypto. Everyone thinks Bitcoin is blockchain. ETH is the same as the Ethereum network, but effectively blockchain it's a ledger. It's a database, a record-keeping database. It has a particularly important features over traditional databases as we understand it, because one, it's distributed. Two, there's no need for trust on the network. So it's a zero trust network. And three, it can be automated and produce itself. And I think it's actually quite an interesting conceptual instrument, because if you actually think about it, the entire legal system as we practice it in Australia and most developed economies are based on zero trust. Like the heart of all contracting is malfides. You don't know who is on the other side. And so we developed the system of laws over the last 1,000 years to deal with, if you don't know your counterparty, how do you put a framework of laws and contracts and codes and rules to deal with it? The blockchain does that, but we're really talking about it at scale. It can record keep all these transactions and allow you to transact on a zero trust network at scale and automate a lot of these what could be mundane features. So that's the blockchain. The next layer is going to be the cryptocurrency, and the cryptocurrencies are effectively tokens that are exchanged on it. And there's the smart cookies. You think about it, and you take a step back, you realize there's actually just a lot of the things we're doing in traditional finance and traditional equity markets are using these zero trust networks to exchange equities and to exchange debt instruments. And there is the potential with the cryptocurrencies, but actually taking a step back, the tokens, to actually do a lot of the things that we're doing already on a faster, more distributed blockchain, but also there's all these new forms of digital assets that are emerging. The one that's really catching people's eyes is NFTs.
Yeah.
But and these are sui generis legal assets of their own class in themselves. But you can actually really see that this new class of assets, this new class of platforms, but also you can see where traditional assets and traditional platforms, why can't you use certificates of title, which have moved from certificates moving to a registry under the Torrens real property system? Why isn't there a natural evolution that you can see that going onto the blockchain? So there's a progression of the traditional, and there's also the new. And so that's two components of that. Web3, Natasha, would you like to say anything about the wonderful world of Web3?
I certainly, most certainly would. So, I mean, Web3, look, it's just trying to think about the internet as it would be, as it can be if it's sitting on distributed ledger technology. So that's just changing the plumbing, really. And there's some really special things about the plumbing that that James has articulated, but the way that it segues into the metaverse is probably where it gets really interesting. So the metaverse, the best way I've seen it described is to think about changing the word metaverse for cyberspace, but thinking of cyberspace in a really immersive way. So you are your avatar, you own items in the metaverse. It's super clunky at the moment, and the reality is most of us experience the metaverse through two-dimensional screens, in a really clunky, non-interoperable way through lots of different platforms. But having said that, I've got lots of kids, and I can tell you that the next generation that's coming, the Roblox generation, they're far more competent in being able to see themselves as their digital twin. So where it gets super interesting from a legal perspective is that the adage was, and this had an impact on all legal systems, that things that happened online were not real. That had a massive legal impact on how taxation took place in respect of the first cryptocurrencies, had a massive impact on property law. What we now know is that digital assets, the things we own, NFTs, any kind of digital assets, we now ascribe them property status. And that's really important because people like to have the law to support them when it comes to being able to retrieve these assets or being able to claim these assets, because people like to have stuff, but they also like other people to know they have stuff.
It's very interesting, actually, because you see, I think the word I've actually heard used as twinning. You've got these sort of real life brands in the real world, like shoe brands and wine brands and all kinds of things, and all sorts of different sort of brands and goods. But you've got the sort of the twin aspect in the metaverse itself. So you've got for example, a pair of sneakers that could be then taken up, and the twin pair of sneakers are sitting up there in metaverse here. So the creation of the assets that people just kind of just probably wouldn't have thought too much about, but there's now a value on these assets, and there's actually, I guess, there's going to be rules and regulations and sort of, I guess, laws around that, and some considerations for business. That's for sure.
Absolutely true. So the reason that this area of law gets very complicated is because digital assets are not static. So all property to date is unchanged. Your phone is your phone. Your house is your house. Whereas a digital asset has the ability to change over time. And one of the ways it changes is it changes through the attachment of the ownership to the asset. It also can be fractionalized in who owns it and what parts of rights they have in respect of it. But it also starts to collect data. And data, as anyone who works in this space will tell you, you can't really own data. You can control data, but you can't own it. So that's why these assets are incredibly complicated. The other thing that's really complicated and why they're different is because they have all digital assets are basically digital twins of lots of enormously disparate underlying things. So you think of them as derivatives, okay? Yep. And if you think of a phone as the digital twin of my jacket as a derivative, and you think of the digital twin of my house, if I've got a piece of land in Decentraland, whatever it is, all of those things are now being swapped, and they're being swapped in a way that is actually making them a form of currency or a non-cash payment scheme. What that is then we've basically said absolutely everything you own, if we flip it up into the metaverse, if we flip it up into the decentralized space, it's now actually DeFi. So everything, even your shoes, if they become something in the digital space, you can swap them. So think of it as mega barter, speedy mega barter across every jurisdiction. And that barter, we're starting to call everything DeFi. But that is itself a legal question, is if it's all DeFi, it's got a lot of regulation around financial services. Then you've got to have financial services licenses. You've got to have market licenses. You've got to make sure you're not ripping off mums and dads who don't understand the products that you're issuing. So this is why the whole, when people talk about it being illegal and complicated, it's not just, have I got some, dark web activity going on? Is it child pornography? It's not necessarily those things. It is the conduct illegal because you're actually providing it's a currency, it's a money. Even if it is NFT, it could have features. When you swap it for something else, it's actually acting as finance. And then it's got lots of rules attached to it. But that's why there's this two big new complexities that ascribe to these assets.
Oh, no, I was just going to say, I think, one of the big things that lawyers grapple with is, the transition from real property and land to chattels, and then people's minds were blown when you had this chosen action that's introduced, and that's like, just this evolution. But now we have this fourth category of these digital assets, and I think that involves a leap in thinking. And I think that in essence, I think the heart of what we're trying to grapple with, and which we believe we've done at Stirling and Rose, is that it's very difficult if you're working 16 hours a day in a law firm trying to gather this paradigm shift and saying, I can be an expert in that so readily. It requires dedicated expertise. It requires study. Like Natasha has, and myself have sat there like for the better part of 5 years gathering, understanding the technology, but actually what does it actually mean for the laws? And I think that's going to be a real challenge, but it's also a real opportunity for Australia, especially in the region as where we can be, because I think as everyone's developing and we have a very sophisticated legal system, I'm confident that we can get there, but it does require a space to actually nurture it and think it through. And it requires like law firms to actually take away from the model of, we will only do it and react to it because there's money there and there's time there, as opposed to let's proactively go there and actually address, well, what can those issues be? Where can and how can we actually lead that?
Yeah, you've then got this wonderful term of actually DAOs. So your DAOs, I mean, which are just this whole new world of like ownerships that sort of present like partnerships almost, and like the complications of a partnership type arrangement. And that they seem like, it seems like there's a world of complexity there as well.
So these are really interesting concepts, and they're interesting philosophical concepts, and they're also interesting ethical concepts. And that in its normal trajectory leads to a legal outcome. So when we first play around, what are we as a society like? Then we tend to move it into, this is an ethical issue or an ESG issue. And then we say, actually, we need to formulate some laws and regulations around that. That's the modern trajectory of something new. Now, when it comes to decentralized activities and distributed activities, it came out of a CryptoPunk response to the financial crisis, where people said, actually, we don't trust centralized authorities. Yep. But what is really interesting that's happening now is the law itself is built on trusting centralized authorities. Just let that land, because what it's doing is it always has somebody to point the finger at. So if somebody rips you off, I want to be able to have a remedy against a person. And in the law, a person can be a company, but I want a remedy. So while people wanted, for the right reasons, they wanted to move away from centralized authorities, what we see happening is a natural centralization. It's a pendulum between decentralization and centralization. And the original purveyors of DAOs, or decentralized autonomous organizations, the purists would say that it's a company that is distributed and is entirely run on code. Now, as you make that hit the law, you hit the suits, you hit the traditional markets, you go, that doesn't actually quite work. That's not to say hybrids of these things won't work. I'm very excited about hybrid DAOs. But the reason is and it was beautiful. I listened to someone speaking at the AFR conference the other day, and it was someone who has been operating a DAO for some time. And as you said rightly, you don't need to actually nominate to be a partnership to be seen by the law as a partnership. And in Australia, most likely you will be considered a partnership if you're operating a DAO. Now, this person said, and it's a very common for DAOs, we will let the people vote on everything. Now, the reality of that is most people don't give two hoots about all the tiny rules in your platform. So what tends to happen again, and this has happened in their organization, oh, look, you've got actually a board of 8 people who are going to make the key decisions in respect of how. And can you hear what that is? From a lawyer, canary in the coal mine, you go, oh, you're a bunch of shadow directors. You actually may be a bunch of directors. You're making material decisions in respect of a lot of people and a lot of money. Sounds to me like you are actually having centralized functions. And this is where, if we're going to approach DAOs really sensibly, and the last Senate report, we talked about having a responsible person. In the States, in Wyoming, in Nevada, you've got laws which are around LLCs. And LLCs are slightly, I don't know if you're familiar with them or the readers or listeners are familiar, but LLCs came about from basically giving partnerships slightly different rights. LLC is almost between a partnership and a corporation. And that actually is probably a better model for a DAO. Yeah.
No, it's an interesting sort of area. I mean, and there's lots of people sort of thinking, well, I could actually set up a DAO and actually, raise a whole bunch of money and do some great, I guess entrepreneurs, they sort of, and this sort of leads me to another point, which is really around, I mean, the kinds of businesses that you'll be having conversations with, or that should be talking to you, are people that are looking to actually alternative ways of doing things, looking to jump into the sort of world of blockchain and crypto. What kind of people are going to be what sort of people are customers or clients?
James, do you want to have a go?
Sure. I think I think the first category you've described is a big part of it. We're talking about international funds, companies, platforms. They're dedicated to this space, that they've lived and breathed, that they've been there since blockchain was first set up and Bitcoin back in the 2000s. But then there's a next component, which is we have existing organizations or TradFi, but traditional financial institutions who are dabbling into the space or considering either they're setting up companies in it, or as they're doing greenfield approaches, or they're actually investing or lending against entities in the space, but they're getting some form of exposure. But they want to know that they can actually get recourse. What is actually underneath, and how do we actually manage it? But then our breadth of span is the dedicated entities, traditional companies which are moving into the space, and it's happening at an increasing rate, but also regulators is being touched on. We do a lot of work with regulators in terms of guiding how it actually works, and it does require an international focus. There's a big focus on the SEC, and usually organizations and regulators around the world will track with the SEC, but it does require a finger on the pulse of how everything is happening, and that disseminates from the regulators down to our work with our clients. And then finally, there's also the startups, and we're really excited about that as well, because they're coming fresh. I think there's a lot of shared values and how we see it, Stirling and Rose. Can we do it better? And that's very exciting. So we run the gamut of the major organizations, traditional and new, regulators, and then to the startups as well. And we're excited about advising all of them.
Yeah.
And so, I mean, again, I read in the article in the Financial Review about potentially different models of actually of charging, like in terms of actually like looking at they reference equity as being an equity type play. Interested actually how you're doing things differently versus billable hours.
So the headline was probably slightly misleading, because it wasn't when you got to the content of the story, but we certainly don't just take equity. But there's a really good, what we did is we've come out of big law. We've been exposed to it, and there's a lot of things that big law can't do very easily because it's just not agile enough to do that. And one of the things is to build assets. And obviously there's a bit of a win-win here, because startups don't have cash. And startups who are emerging tech startups, they really need legal advice. So even from the most compassionate part of ourselves, it was really quite heartbreaking to not be able to assist people who were actually, there are criminal penalties associated with getting some of these things wrong. So not being able to assist people who absolutely have legal problems, they're significant legal problems, and they're doing really cool, exciting, innovative stuff, that's really stupid. So what's one way, if they can't give you cash, what is the way to make it happen? And it's it's very common with VCs, it's very common with investment bankers. is to say, okay, well, we'll take a risk on you. You're a bit of a lottery ticket for us. We'll do for some hours from you on corporate structuring. We'll do some hours for you on your regulatory work, financing, and sort of act as that GC as a service if we think that there's some legs in that business. Over time, we would like to think that in fact, if you have Stirling and Rose sitting on your cap table, that's a bit of a shining light to other potential investors that this is a kosher business, if you will. Yeah. But other financial model, absolutely. We tend to do fixed fee is our most common. But we're not a law firm who wants to send you a 20-page narrative of every 6 minutes that we spent with you. It's not what we're going to do.
Yeah, and I think I think what actually happens from a consumer point of view, I mean, knowing what sort of costs you're up for and knowing what it looks like, and where there might be some variations and where things might have to cut in because this just changed and that's changed. It's a really good, fair way to do business. I mean, it's attractive. People want to know what roughly they're up for.
It's the subscription model, isn't it? And it's it's meeting the world where it is. Having said that, there is a reason law firms have evolved the way that they have. So when you are operating a law firm, there's a bunch of legal practice complexity that you also have to moderate. So, for example, even if you were to read our engagement letters, we can offer you an hourly model, and we need to be able to explain to you how we spent our time, because that's how the legal professional acts are set up. So if someone wants to complain, you need to be able to tell them how you spent your time. Yep. So these are really interesting questions, and probably ones where the law needs to evolve, particularly as machines themselves get more involved in giving legal advice, because then the time spent is not actually the indication of the value.
And are you set up in such a way that I guess, and I guess from point of view of like law firms, because we've got a lot of subscribers of law firms and some accounting firms as well. I mean, are you guys, they've got a client that's, for example, that might be for some reason in this sort of area, and it's not their expertise and it takes a while to skill up in it. So should they be probably chatting to you or referring stuff to you in that way?
I think so. I mean, it's the same way that you tend to often go external for tax. Mm-hmm. We consider ourselves commensurate to highly specialist tax advice. So I would say, particularly after the AFR article, we would have got hundreds of touch points, and a lot of them were for third-party service providers who have clients sitting there, and they're not necessarily law firms, but they have clients sitting there who they know are, as James said, they're institutional, or they're big new startups, but have got big balance sheets, and they're kind of needing that legal advice, but they can go traditional and they're not actually getting the really, really pointy end of what's happening.
Very good. And I mean, what should law firms do to prepare themselves, I guess, for what's going on with Web3, blockchain, and crypto?
You can't ignore it. That's the main thing. James, have you got it?
I think that there is the philosophical question: is it a thing? And I think that's actually one of the biggest problems that's a lot of law firms have struggled with. And look, they deal with traditional clients, and so they say, oh, they see these new things, they see something on Instagram, it's not a thing. Why were we wasting their time on it? But it's been here for 6-7 years. There's a tremendous amount of money, and big players are moving. And so I think that if big law can accept the fact that it actually is the thing, which we genuinely believe it is, then I think what it actually requires is dedicated time and learning to actually get across it. And it isn't doing it on an amateur basis. It's not doing it on a part-time basis and doing like reading 1 hour of readings per week. You actually need to spend a lot of time. Natasha and I mentioned, like it's taken us quite a bit of time to understand how does Web3 work, how NFTs work. And look, that may change in the future, but you have to understand the basis. And then you start to, as you go with first principles, you apply it on top. But then, and this is where it's sort of antithetical to the model of a firm that charges by the hour and wants to stay profitable, because that's time investment. It's not necessarily one that you're going to reap the benefits immediately. It's going to be something later down the track, and it has to be disseminated across the organization. And so, as Natasha has said, law firms have evolved in a very particular way, and they're very successful in what they do, but they move like the institution of law in a very slow, methodical, reactive fashion. But I do believe there has to be some meaningful time investment towards the future. There has to be some proactivity, because otherwise clients, you end up with 2 problems. clients obviously have a demand for these services, and you either have major law firms saying it's not a thing, we're not going to waste our time on it, or we can't advise on it, or we have people saying we're just going to Google the response beforehand and we're just going to try our best, and that's bad advice. Like it requires a body of specialist expertise to actually deliver what clients need.
I mean, I look at it's actually interesting because we just recently sort of just turned on the crypto flag onto Shopify to accept crypto for Shopify. And I think to ourselves, if we're not specialists in this sort of area, but if there's other firms as well, if accepting payments and that sort of area becomes more prevalent, you think to yourself that the average business is actually going to be get themselves immersed, particularly as it might relate to treasury. So they might be sort of holding some money in different sort of currencies or tokens, or investing from a treasury standpoint. And you say to yourself, well, that's not something that the average accountant or lawyer may have expertise in.
And also, even just going to accounting, David, there are some really, there are multi-billion-dollar companies that didn't exist 3 years ago, which are there to offer custody. They're there to offer brokerage. They're there to offer lending. These are really sophisticated. I think of DeFi, and I think of what's happened with cryptocurrencies to be almost like a tree which has so many roots and so many branches and so many leaves now. It would be really hard to chop it down. There's so many people, there's so much money, and it's been put into so many places. However, it has to meet the ground, has to be tethered to the ground, and the ground is law. And the ground is also the fact the whole lot of it is actually still built on Web 2.0.
Yep.
And it's still all built actually on fiat currencies, because to enter in, you've got to deal with those fiat currencies, and to exit, you've still got to get to fiat currencies. If people think that Web3 is going to evolve in such a way, or a distributed way, that governments around the world will throw back their hands and say, oh, well, we don't care about tax anymore. Oh, well, you guys, you go and just operate between yourselves and pay between yourselves, and we won't pay attention to your fundraising. That's not going to happen.
No.
Okay, so what is going to happen is, as your regulators get closer to it, as more people like us come in and help with the literacy, because literacy is the primary problem that James has identified. Literacy is not there. You need to take time to be literate. To other law firms, you need to be literate, because you cannot advise on this properly if you're not literate. And it is, as I said, it comes down to criminal penalties. This is not something you can get wrong. The last thing for lawyers is, we're seeing it in some jurisdictions already, particularly in Canada. It's already implied in other jurisdictions. Legal duties require that you provide clients the most efficient service possible. So if you can do that with a machine, you can't do that without a machine. You'll actually be breaching your legal duties. So there's a very significant reasons as you can't put your head under the blanket, under the doona. You actually need to start listening, learning, and being able to be a canary in the coal mine. I think lawyers have a duty to get involved in this thing. I
totally do. I do too. I mean, that's what it's fantastic what you guys are doing, and I guess from point of view of making other, I guess being a source of literacy around that sort of area. I guess businesses like ourselves, we're looking to lawyers to educate us to a certain level, so we know when to actually call lawyers in, what kind of services we're going to need, and how it's all sort of going to work. So I think it's something brilliant. It's brilliant. So if people want to find out more about law firms, accountants, or businesses want to find out more about you guys, what's the best way, or get educated? What's the best way?
Well, email any of us at our Stirling and Rose. We have a website, www.stirlingandrose.com, and you can see all our emails and phone numbers. We're all there. And also, obviously, LinkedIn's a great platform. However you want to get in contact, we are ready, and we've tried to gather some of the smartest people in the room together, and we're there to help.
Brilliant. Natasha and James, thank you so much for your time today. It's been really great chatting with you, and very educational.
Thanks so much, David.
It's a pleasure.